What is going on, everyone? My name is Mark Reel Jr., the Father's Rights Attorney, and you're watching another episode of the Father's Rights Playbook. And on today's episode, we are going to talk about how domestic violence impacts your custody. And to discuss that with me is senior trial attorney out of our San Diego office, James Rudolph. James, how are we doing today?
Doing well. How are you?
I'm good. So let's hop right in. And this is one of the most impactful topics, I think. At one point in time, we did a study, and it was 75% of our clients had either faced a domestic violence restraining order hearing, or they had been accused of some sort of domestic violence throughout their divorce or child custody process. This is an unfortunate thing because in the state of California, we have some of the strongest DV laws, some of the most liberal DV laws in the country. So I'll pose this to you to start the conversation off. How can domestic violence impact your custody arrangement?
So you're right. In California, it's a preponderance of the evidence, which is a low standard, meaning it is more likely than not that the allegation is true. And you have issues related to custody there. First, you have to show a qualifying relationship. You had a child with this person, there was a dating relationship, or you were married to them. And then abuse, which could be what they call coercive control. It could be harassment. It could be disturbing the peace, which is kind of destroying somebody's mental tranquility. And then if that is alleged, you have an initial hearing. And ultimately, if it is demonstrated that there was abuse, it can have serious consequences for your custody case, because there's a presumption that a parent who has been found to have engaged in abuse is not a fit parent. And it's a rebuttable presumption, but it's difficult to overcome that presumption that you have abused and therefore should not be with a child.
So rolling it back to what can constitute domestic violence, one of the biggest misconceptions I get from clients is, well, I never hit her. You mentioned one. Really, since 2020, we've seen a gradual expansion of the definition of domestic violence through the code. In 2020, we had the addition of coercive control, and now through case law. So walk us through, what are some of the common things that maybe aren't that physical violence that we see that could rise to the level of being domestic violence by definition of the family code?
So it's true, the code itself says that it is not limited to physical abuse. So it can be anything from harassing emails, harassing phone calls, assuming the person has said, I don't want these anymore. Harassment is typically a pattern 2 or more times when somebody has indicated these are not welcome messages anymore. It can be stalking, that can be actual physical stalking, or it can be online stalking somebody's social media page, posting negative things about them. And so it is not, and coercive control, as you mentioned, is one. That's really like you're not letting somebody out of the house, or you're controlling their finances, or you're cutting them off from their friends and family, or maybe even withholding a passport so they can't go anywhere. And then disturbing the peace, which is a mental thing. You kind of destroy or undermine somebody's sense of tranquility and well-being. You're nervous and anxious all the time that they're going to show up. So that kind of thing can be abuse. And if there is an order in place, a violation, even a technical violation of the order, is itself abuse, and can constitute grounds for renewal of the restraining order.
That's probably one of the bigger mistakes we see made, is that a violation, no matter how unjust the temporary is, no matter how we can shoot down, we've had our attorneys have 3, 4, 5-day trials where they cut down every single allegation of abuse, but you violated the temporary restraining order, and that in itself gives the judge grounds to grant a restraining order against you.
Yes, and there is, of course, the First Amendment, and the courts have struggled with that. We all have First Amendment rights, but this kind of allegation trumps that. So you cannot engage in this abusive communications, and it's a big thing. The technical violation is there. I had a recent case where he had complied with everything, except that on one occasion he had reached out and sent an email, which was an innocent enough email, but it was a violation. That was grounds for the renewal of the restraining order for 5 more years. And the court indicated that it was a technical violation, but that's enough.
And he was lucky because on the renewal, it's 5 years or lifetime.
Yes, it could be beyond 5 years, indefinite.
Yeah. So let's fast forward then. So we have the initial part of it, what can constitute domestic violence. So let's turn to the point where, let's say, unfortunately, there's a restraining order that goes in place. And with the initial restraining order, it can be, typically you see 1, 3, or 5 years, but it's anywhere between 1 and 5 years is that initial period of restraint. What happens to custody when that restraining order gets granted?
Well, the other parent is presumed to be the one to receive sole physical custody. And as I mentioned earlier, it's a rebuttable presumption. That just means that through evidence, you can overcome the presumption that you are not a fit parent.
Don't count on it, though.
No,
the case law is extremely strong.
It's very difficult. You have to go through sometimes a 52-week batterers intervention program. You have to take parenting classes. You have to go through therapy. You really have to show that you have changed and that you've complied with, say, your therapist's prescription for self-improvement, take these programs, and even then, it can be denied. I've seen it denied after 3 years of full compliance.
Yeah.
It depends on the severity of the restraining order.
Yeah, and you can do everything right after the fact, and there's no guarantee for that period of 5 years that you're going to be able to rebut that presumption.
Yes. I had a case where the judge said, yes, it's been 3 years, you've done everything, but based on the severity of the original accusation and the fact that it was shown that you did this, we don't think you should have access to your child yet because there were such serious allegations.
Yeah. So that's the legal side of it, the legal custody. So I think probably the more important one we deal with in the aftermath of this, and whether it's a client that comes in after they've gotten a restraining order granted, which is most common, or it's that we've done the trial, we've went through that entire process. What happens to that physical custody?
Of the child?
Yeah.
Well, I mean, if there's an order in place granting, say, mom primary physical custody or even sole physical custody, depending on what the order says, you might have no contact with your child. And the point is that California really wants it known that they do not tolerate domestic violence. And so the consequences are severe, and it can be something as light as 2 or 3 times of harassing somebody via phone or text or email. And depending on the nature of the relationship and the allegations, you can essentially give up your custodial rights.
Yeah, I think a lot of times, even in the more minor cases, a lot of times the restraining order gets granted, dad ends up on supervision, which that's a whole nother episode, a whole nother set of problems and issues with when this gets ordered. But you may end up with 2 or 3 times a week of supervised visits, and then we have to go back into court to even get that expanded.
And then the question of who pays for supervision, because it's typically a third party, and they charge for that.
$100, $200 an hour. You get 8 hours a week. I don't know many people who can afford $3,200 a week or $3,200 a month to see their kid.
And what I describe as the indignity of having somebody watch you as you watch your child. Almost as if you're a child yourself. Yeah.
And this is completely me. Don't put this off on James. I think 99% of cases, supervised visitation is the crutch a court leans on, not something that's actually necessary. I think the scarier part of that is a lot of times you're going to have to work through that period. And there are very few cases where you see overnight stick with a parent who had a restraining order grant. So you're going to, at minimum, you're going to lose overnights. But there's case law, and the toughest part for attorneys right now in DV, in my opinion, is the volume of case law. The DV groups, when these new laws came into effect, they appealed and they appealed and they appealed, and they got a ton of very favorable rulings for custody after restraining order. So the judge technically, until you rebut the presumption, can't grant you anywhere close to 50%. I think with the case law, it's like in the 30s is even a stretch.
Yeah, it's true. It's the consequences are severe. I would also mention just, for the fathers out there, it's often the case that the allegations are false. And it's somebody scheming and positioning for an advantage for custody.
Yep.
And we do represent fathers who have been falsely accused of sexual abuse, physical abuse, and we go in for an evidentiary hearing, and we have witnesses and cross-examination. And so we feel confident that if they are false, we have a good track record of undermining the allegations, getting you the custody that you deserve.
And that's where the worst part is. They come in and make these nasty allegations. They come in and say these awful things about you. And then you, on a technicality, violate the TRO. I don't know how many times. Sometimes I think we lose more cases because of that than we do on the initial allegation.
Yes, and it's tough. Sometimes clients don't understand that. It's just a technical, what they call de minimis violation, but that is enough.
You can't tell your friend to reach out to her. You can't say, it doesn't matter how polite the email is. You just simply can't do it.
Yeah, we had a case where he was reaching out via social media, and the judge said, well, that's your right. It's a First Amendment right. But the email you sent directly to her, that was the violation, and that was grounds for renewal of the restraining order. And of course, he was very distraught, but that is the law of the land.
Yeah, unfortunately. Well, James, thank you so much. That's a lot of really, really good information on the cross-section of domestic violence and custody. For all of our viewers out there, thank you so much for watching and listening. We'll be back next week with another episode of the Father's Rights Playbook.
Thank you.